do our May. Good afternoon, everyone. Welcome to our May 14th webinar entitled Who is Responsible for Taking Care of Weird Stuff in the Community? My name is Alina Gilbert, and I'll be presenting this lovely webinar today. But before we get started, let's go through some of our housekeeping items, and then we'll get going. So first of all, thank you for joining us. Really appreciate you guys joining and attending these webinars. It's very fulfilling. So on your screen, if you have not done this before, the bulk of your screen should be the PowerPoint. So you should be looking at this funny little meme here. And on the left side is the video of the presenter. That'd be me. Hello. And on the right side, you're going to see a little menu, and kind of off there on the right in the corner, it should be a little chat sign. So that's what you're going to click on, and that's where you're going to enter your questions as we go through this webinar. I will save all questions for the end because a lot of times, you know, you'll type in a question and then it gets answered later on in the webinar. So it's just more efficient to wait until the end, and plus I want to make sure we have enough time to go through all the materials before we start answering questions. So again, I'm not ignoring them, I'm just saving them for the end. If you are having any audio or any video issues while we're doing this, on the bottom of the screen you should see a little button that says audio or video issues, question mark. Go ahead and click on that. It'll take you through some steps. Hopefully it will resolve the problem for you. You will be receiving 1 CMCA credit for this class, assuming you stay on for the duration. And it will be automatically generated and emailed to you. Once you get the email, which will probably be today, once you get that email, please download that picture. Save it as something, because the picture of your certificate, it tends to disappear. And if you don't download it and save it after, I don't know if it's a couple days or what, it's going to go away. And then you're going to be emailing us saying, I didn't get my certificate. So please, as soon as you get it, just download it, save it, and keep it somewhere safe. And as a reminder, this presentation is going to be recorded, so if you think it's amazing and you want to watch it again, or you want to tell your coworkers to watch it, you know, feel free. The only caveat is no CMCA credits for watching the recorded version. Only the folks who are on the live webinar will be able to get the credits. And then last but not least, at the end of the webinar, you will have a little pop-up survey. And like, again, for those of you who have been to our webinars before, you know how this works. And I always beg and plead that you take a couple minutes and just fill it out, because that's really what lets us know what we're doing right, what we're doing wrong, what we can improve on, what you're loving, what you're hating. And, you know, there's no such thing as bad feedback as far as I'm concerned. So please put in whatever comments, whatever feedback you would like. All right. Oh, got through that pretty quick. So let's go ahead and get started then. So I'm going to tell you something. I thought this would be a really easy webinar to put together when I first started on it. And then I realized it wasn't. Because weird stuff, it could mean so many different things. And there's so many weirdnesses that happen in the context of HOAs and condominiums, right? We see all sorts of weirdness, and trying to summarize it or somehow label it is very difficult. So for the purposes of this webinar, I decided to divide this into 2 sections. The first one is weird stuff maintenance requests, and then weird stuff complaints. Some of them kind of overlap with one another a little bit. Like I said, it was very difficult to figure out how to divide them. So we're going to go through a few things, and we're by no means are we going to cover every weird situation that's out there, because as you know, they're endless, and just when you think you've seen it all, boom, there's something completely new and different that just leaves your jaw dropped. So for the purposes of this webinar, like I said, this is how we are going to cover it. So let's go ahead and start with maintenance requests. And these are just a few examples that I thought of that are not super traditional. I mean, maybe they're getting more traditional, but they're not like the kinds you typically get. So rodent infestations inside the homes. I have bats in the attic. Get rid of them. There's beehives outside on my unit. Get rid of it. And there's a lot of goose poop in the yard. And it's either going to be clean up my goose poop or get rid of the geese. Have you guys ever had that? Get rid of all that wildlife that's natural to this area. So we consider those kind of weird type of maintenance requests, not because they're really weird, but because you don't really know what to do with them. So whenever you get a request for any kind of maintenance, for lack of a better term, get rid of the rodents, maintain, clean them up, get rid of the bats, get rid of the beehives. Those are all type of maintenance requests. So when you get those requests, we really want to look at the analysis when it comes to maintenance. And it's like any other maintenance request, whether it's fix my drywall, my window broke, replace my window. The analysis is going to be exactly the same for weird requests as it is for our kind of typical everyday requests. And so the rule is, if you own it, you are responsible for maintaining it, for insuring it, and for repairing it. Period. End of story. Unless there's an agreement that shifts these obligations to a different person or entity, or the law shifts it. Okay? So let's go through this. Let's see what it takes to figure all these things out. So we'll talk about ownership first. So there's a difference between planned developments and condominiums. And a planned development is anything that includes lot ownership. In other words, homeowners own the land upon which the residence sits. They also own the residence itself. And if the lot lines are further out and there's like a yard and things like that and driveways that are within that lot, that is all going to be owned by that homeowner. What are some examples here? So your townhomes, even though you have a dividing wall, the party wall, they are still going to be planned developments. So a townhome per se is not a legal type of development. It's just how we refer to planned developments where there's shared walls. Your patio homes, maybe they're detached patio homes. Maybe you have other kinds of homes where some are attached, some aren't. But the key here is that there is an ownership of land by the homeowners. How do we know if we're dealing with a planned development? Well, first of all, don't look at how it looks, because a lot of times we have things that look like townhomes that are really condos, and things that look like condos that may be townhomes or that may be planned developments. So don't necessarily look at the way the buildings are structured. But if you look in your covenants, your declaration, if you see the word lot in there, okay, that's a pretty good hint for us that we're dealing with a planned development because the homeowners own the lot. The other thing with planned developments is the common area ownership. Under Kiowa, the common area in a planned development is always going to be owned by the association. In other words, there's going to be a deed out there somewhere where the developer actually transferred ownership of the individual common element tracts to the association. So you should be able to find those deeds with the clerk and recorder's office. And just as an aside, if you don't have copies of these deeds and you are a planned development, I would recommend just getting them so you have them in your file in case an issue ever comes up. All right, so planned developments. And planned developments, again, as an owner, I own my entire residential structure and any improvements that are still within my lot lines. The hard part with these types of planned developments is sometimes we don't really know where the lot lines are, and that's where we run into trouble. But let's talk about condominiums. Condominiums, again, don't look at how they are physically structured. I've seen condominiums that look like single family homes, and you would look at it and think, oh, for sure, that's a single family home. But guess what? It was created as a condominium. So how do we know if it's a condominium? Couple of giveaways. So in a condominium, homeowners own what we call the airspace. They own the land. They don't even own the structure. They only own that airspace within whatever the boundaries are of the unit. And so if you're looking through the covenants, you might look for verbiage like airspace, individual airspace unit. You are also going to be looking at the common elements, because in a condominium, the common elements are not owned by the association. They are owned as by all the homeowners collectively as tenants in common. And so a lot of times what I get when I explain this to folks, especially if it's like at a homeowners meeting, they say, well, then if we own it, then we can dictate what happens to it, and we can be in charge of what the association does and doesn't do on it. And the answer is no, that's wrong for various reasons, but mostly because Kiowa, the Colorado Common Interest Ownership Act, is very clear that the association is responsible for the common elements and for managing the common elements and maintaining the common elements. So, you know, that argument that some homeowners try to make does not really go anywhere. And also most declarations also require that the association maintain the common elements. So just because the association doesn't technically own them, that doesn't mean it has any less right to regulate them, to adopt rules governing them. It's just a different kind of legal ownership. All right, so in a condominium, when we're trying to figure out ownership, it gets a little tricky, because what happens is first we got to figure out, where does the condominium end and where does the common area begin? So most of the time when you're looking in your declaration, you're going to be looking for either definition of the airspace unit, or sometimes you'll see something that says boundaries of unit. And typically what you will read is it's the unfinished surface of the perimeter walls, floors, and ceiling, or the uppermost floor, ceilings, lowermost floors. And that leads to the question of, well, what's a finished surface? Is that like my wallpaper, or does that actually include the drywall, or does it not include the drywall? What is it? What's included in all of this? And that's where a lot of confusion starts, is because we don't really always know what's what. Now, I will tell you, for your condominiums that were created after July 1, 1992, which is when Kiowa came about, Kiowa actually has a provision that explains this, and it says, if your documents say that it's the perimeter walls, floors, and ceilings, then for the purposes, you know, of ownership, the drywall is considered part of the unit. The doors and windows are limited common elements. Any utilities that are within the unit are the unit. Once they exit the unit, if they only serve that unit, they're a limited common element. If they serve other units, they're general common elements. So we have that guidance. But if you are a pre-1992 community, that section doesn't actually apply to you. And so we are kind of left wondering a lot of times what's really included. And in those cases, we will typically recommend adopting some sort of a resolution by the board to clarify exactly what's part of the unit and what isn't. But basically, that is how we would determine the ownership of any particular component. Now, obviously, this is convoluted enough that, and you're going to hear me say this over and over again, but it's convoluted enough that you probably want to get an attorney involved. But I think it's also important that you understand, you know, kind of the basics of what's included in this analysis. So then the next issue is, what constitutes an agreement? Because we said, remember, if you own it, you maintain it, unless an agreement shifts that obligation to someone else. So what could constitute an agreement? Well, you know, first and foremost, we look at the declaration, where we look at the map, the articles of incorporation, bylaws. Sometimes there's maintenance agreements out there. For example, you might have seen agreements where an association allows an owner to put an improvement on a common element, and then the agreement says that the homeowner is not going to be responsible for that common element as far as repair and maintenance. That would be a good example of an agreement. Sometimes we see agreements between associations in like metro districts where the districts agree to take on maintenance of common elements instead of the association. That would be another example. But these are the types of documents, you know, I'm talking about. So obviously, just because a homeowner owns their residence in a planned development, there may very well be some provisions, and there typically are, in their declaration, especially with like townhome type communities, that will require associations to maintain certain portions of the exterior, the roofs. They might require the association to insure certain portions of the exterior, or sometimes even some portions of the structure. And I always get the question from boards of, well, if we don't own it, why do we have to maintain it? And the answer is because you have an agreement that says you have to do it. And that agreement is the declaration or whatever else. Now, your maps are also super important because a lot of times in the notes sections, there will actually be some notes about who's responsible for maintaining certain things. Now, it's not always there, but sometimes it is. And therefore, you don't ever want to bypass the maps when you're trying to determine whether there's an agreement shifting those obligations. Okay, so that's kind of step 2 of the process. But remember, we also said an agreement can shift it or the law can shift it. So when we talk about the law shifting those obligations, what are we talking about in that case? So one of the things we're talking about is if someone did something wrong and caused the damage because they did something wrong. So that could be something akin to negligence. It could be something where I purposely did this. It could be a criminal act. And in those types of situations, the law might shift that obligation. So, if, for example, if we can prove that a homeowner was negligent and started a fire that damaged some common elements, and I'm not, let's pretend insurance doesn't exist because we're not going to get into that. And, you know, we have to repair it as the association because maybe we own it or because the declaration says we have to repair it. Then if we can determine that the homeowner caused it by a negligent or willful action, then most covenants and Kiowa allow us to charge that back to that homeowner and have them reimburse the association for the repairs, right? So sometimes the law can shift either the requirement to repair or at least the obligation to pay for the repairs to someone else. The law can also do that by way of just specifically dictating these things must be maintained by this party. Now, Kiowa doesn't so much do that with maintenance, but it does do it with insurance. And I know I said we wouldn't talk about it, but I just want to give you an example. So Kiowa says if you're a post-Kiowa community, you have to insure the common elements, including all the limited common elements, no ifs, ands, or buts about it, no matter what your declaration says. So it doesn't matter if it's a condominium, it doesn't matter if it's a planned development, you association are responsible for insuring. So that is a situation where we have the law dictating a specific responsibility to a specific party, and it's not going to get shifted through an agreement because the law in this case is going to trump any agreement you might have. Okay, so when we're talking about is this obligation shifted by law, that's the type of things we're talking about. All right. As an aside, when the association has an obligation to maintain or repair manage components in the community, okay? It also has the full discretion to determine when it's needed, when it's, who performs it, how it's performed, and whether or not it's needed at all. Now, I'll tell you though, obviously that doesn't mean if there is some, a big gaping hole in the exterior of a condominium building that the association can ignore it. But it means to the extent that a homeowner may be demanding something, paint my, building, and the board does not think it's time, or we have a paint cycle and it's not ready, it means we don't have to paint the building just because the homeowner wants us to do it. It means we have discretion to determine when that happens. Okay, so again, keep that in mind, because a lot of times what I hear from both managers and from board members are questions along the lines of, well, the owner says we have to do this because we're responsible for maintenance. Well, that's all well and good, but the owner doesn't get to dictate what, gets maintained when and where. Now, if repairs are needed, absolutely, we should be making repairs. But when we're talking about aesthetic improvements or just improvements in general, you know what? That is going to be up to the board of that particular community. All right. So we've talked about kind of the process for figuring it out. So let's actually look at these examples that we had originally, and let's see what we can do with them. And obviously there's going to be a lot of it depends type situations, and they're all really it depends, because you change the facts just a little bit, you might change the outcome, right? So kind of take these with a grain of salt, because what we're really doing is trying to figure out how we think through these things. It's not by all means that every single time this is what's going to work. But let's talk about rodents first. So we talked about rodent infestation in the home. So the first thing is you got to figure out, well, where are they coming from? Now, if there is a big old crack in the siding and they're getting in that way, then who is responsible for maintaining and repairing the siding? Is it the association or is it the homeowner? If it's the association, based on the analysis we just did, then there will probably be a need for the association to come and repair that siding so that the mice or the rats aren't getting in, or whatever rodent is in there, right? If it's they're getting in because the unit owner, the homeowner, is a slob and they're a hoarder and it's a mess inside and they're all coming in through natural avenues, because we know that happens, then, and the homeowner is responsible for their interior, well, guess what? Then it's not something that the association would be responsible for, especially when we add the component of, does the law shift the obligation? Even if the association did have an obligation to maintain the interior, and if the homeowner is causing these damages because they're not keeping the property clean, or whatever it is, then again, that is something that could likely be shifted back to the homeowner. So when we talk about, interior unit damage, in general, and in most cases, we see that the homeowners end up being responsible for that. But there are always situations where perhaps the association did not properly maintain perhaps the siding, and it cracked and we didn't get it fixed for years and years and years, and now there's an infestation, and then you're going to get accused as the association of being negligent and not properly maintaining. Whether or not you were or you weren't, that's going to be a whole separate analysis. And that is something that if you end up, in front of a judge, that's something that the judge is going to have to determine whether the board acted properly under the circumstances and whether it did what it should have done with respect to the maintenance and repairs of the exterior of the home. Okay, so as you can see, just from this, it's not a clear-cut answer, right? It's never going to be yes, it's the homeowner, and it's never going to be yes, it's the association. It is all going to come down to the specific facts, as well as knowing which components are damaged, which components need to be repaired, and then going through that analysis of who owns it, is there an agreement shifting it, and is it shifted by law after that? So you're always going to go through those steps. All right, so let's talk about bats in the attic. That is another one that is kind of odd, but attics in condominiums can be very, very tricky and confusing. Remember how I said we sometimes can't tell what is included in the boundaries? Now, regardless if you're a post-Kiowa community or a pre-Kiowa community, Kiowa doesn't talk about attics specifically, okay? So a lot of times what we need to do with condominiums is we have to pull out the condominium map to see if attics are labeled as limited common elements. A lot of times they are, sometimes they're not labeled at all. And now we're kind of in a situation of, are they part of the unit or not? If it's an unfinished portion of the building and the unit is defined as being enclosed by the perimeter finished surfaces of the walls, floors, and ceilings, I think there's a very good argument that the attic is not part of the unit because it is not, there's no interior finished surfaces within that attic, and therefore it's not part of the unit. Sometimes it's not as clear, right? So be careful when you have anything to do with attics. You probably, unless you have some clear language in your covenants that say attics are, or you can tell by looking at the map what attics are common elements or they're part of the unit. A lot of times you are going to be confused and there may not be a correct answer, or you may need to adopt a resolution clarifying whether attics are part of the units or not. Okay. So, but the bats in the attic, it's going to be a very similar analysis because the questions are going to be, how are they getting into the attic, first and foremost? Now, are they getting in through because there's something wrong with the roof tiles and they're ripped off and there's a hole there and they can get in that way, and the association is responsible for the roof? Perhaps. That might be then an association issue if the association is responsible for maintenance of the roof. If they're getting in naturally because there's like vent slats in there and they can get in through that, well, then we start looking at, is this something then that needs to be addressed from the interior of the building? Because maybe you need to put, I honestly, I'm just coming up the top of my head because I don't know how you catch bats, but bat traps, something, lure the bats or something that they hate that makes them leave the attic space. And then the question is, okay, so if we need to get rid of the bats from the inside, is that attic a common element? That is perhaps the association's responsibility? Is it part of the unit? Is it the homeowner's responsibility? So you're going to have to go through all those steps to try and figure out whether or not that is going to be then an association versus a homeowner responsibility. Beehives. So most of the time when we're talking beehives, they are on the outside of the residential structure. I don't typically see requests for maintenance when they're inside. I don't even typically see them being inside, but they could be in the gutter. They could be like underneath like the roof line. Sometimes they're right on the cusp of the garage door. So, they could be anywhere. And I do hear about a lot of situations where homeowners are reaching out to their associations saying, you got to get rid of this. So the analysis, again, is who maintains, first of all, the exterior. If the homeowners are maintaining their exterior, that's what we determine, then it's not going to be the association that's getting rid of it. If the association is responsible for the exterior, Then the next question is, since we have discretion, right? Since we have discretion on what kind of maintenance gets performed, when it gets performed, who performs it, do we have a right to say this isn't that big of a deal? And if you want it removed, you do it yourself because we don't think the association should be doing this. Well, technically, yes. Could it come back to sting you in the butt? Yes. Think of situations, I always think of worst case scenario. Homeowner requests removal of a beehive. Association says, no, we don't think it needs to be removed. It's not real big yet. It's not causing any problems. Homeowner tries to remove the beehive, him or herself. They got stung. They have a horrible allergy to bees. They go to the hospital. God forbid they die. Just think of that scenario. Would there be a liability exposure to the association in that case? Oh, heck yeah. Heck yeah. So I personally take a more conservative approach with things like the beehives. I would say just get rid of it. It is the safest option with respect to liability exposure. It's not super expensive to have somebody come out and get rid of it. So I would say you're going to spend more money fighting about it as soon as they get their attorney than it would cost you to just have somebody knock it down and get rid of it. So, but I will guarantee you're going to find attorneys out there who are going to say the opposite. No, let it be there. Again, it's how conservative do you want to be? And in the day and age where we have courts that look at the tiniest little thing to find against associations, we really want to be careful. Absolutely. Okay. Goose poop in the yard. So again, we start with who is responsible for the maintenance of the yard. Now, sometimes you will see language that says, for example, if the yard is a limited common element, let's say you have a little enclosed patio and there's some land around it and it's a townhome, and the declaration says that the homeowners are responsible for like the patio, but the association is responsible for the land, regardless of whether it's enclosed. And we see that the association has the responsibility for that landscaping, but then it says, but the homeowners have the obligation to keep that area neat and clean. So if you see that language, it is logical and absolutely reasonable to conclude that cleaning up goose poop is not as much a repair or maintenance issue as it is a keeping it clean issue, right? So I think it would be reasonable in that type of a case, even if the association has an obligation to maintain the landscaping, to say it does not have the obligation to clean the landscaping. And if you don't like goose poop, you are going to need to clean it up yourself, homeowner. And furthermore, is it something that the association would even consider a necessary maintenance item? If it's on a general common area and the homeowners don't want to walk around in the common area because there's goose poop everywhere, and we're going to get into like native species in the next section of the presentation, but geese we're not going to get rid of the geese. We can't get rid of the geese. They're here to stay. They're not leaving us, and they will continue to poop. So if we clean up the goose poop, how much more is going to be there tomorrow, right? So I think that's an analysis that the board would have to do, and again, use its discretion to determine how often we clean the goose poop. Obviously, we don't want to leave it there all summer and have it be completely gross, but if we have a cleaning schedule and a homeowner says, I want you to clean it more often, that doesn't mean that that's what we have to do. So again, lots of ifs, ands, or buts in these types of situations, and they are weird, but these are the things you should be looking at when you get those types of maintenance requests. We're going to take a minute to breathe and have a comic relief. Love this. Love Dilbert. You can always stick in a good Dilbert cartoon in any presentation, as far as I'm concerned. All right, let's go on. So let's talk about complaints. And some of these are similar, but not quite the same. So we got rabbits eating gardens, which is similar to, you know, the goose poop. We have woodpeckers making way too much noise. My neighbor has a camera and it's pointed at my window or at my door, make them stop. My upstairs or next door neighbors are always fighting, they're yelling, they're screaming, and they're calling the police out constantly. Every day, the police is there. It's a nuisance, make it stop. Do those sound familiar to anybody? Have you ever had stuff like that? They come up, they're weird. You're not really sure what to do with them a lot of the times. So what we're gonna do in this section of the presentation is I'm gonna go through each of these examples and we're going to talk about them and talk about the type of things that we should be looking at or that we can look at to help figure out whether the association needs to be involved and how. Because that's really the hardest thing to figure out sometimes. Is this really something that the association should be doing? Is this something we're responsible for? Is this an owner-to-owner issue? What is this? So let's go ahead and start with our rabbits in the garden. So as with the goose poop, we're going to look at who is really responsible for the maintenance of the garden. And even if it is the association, is there a duty to remediate natural wildlife in the area? So rabbits live here, right? Is the homeowner complaining and demanding that the association ensure there are no rabbits in the area? I don't think that's a reasonable complaint, right? I don't think there's really a cost-effective mechanism to remove all the rabbits, but we also have other types of animals in the area. We might have voles, we might have coyotes, we might have foxes. I mean, you name it. We're going to have other types of animals depending on where this community is, but you're going to have something. And so would it be considered reasonable for the association to try and remove everything? I personally don't think so. I think most attorneys will tell you, no, it's not a reasonable complaint. That's not a reasonable demand. Is there a duty then to make sure that the rabbits aren't eating the landscaping? I could be Joe Blow and I'm really angry in general. I'm an angry human. I'm unhappy with life. I'm unhappy with everything. And I am certainly unhappy that the pretty flowers outside my window are no longer there because the rabbits, come and eat them and they're gone. And now my unit is ugly. And now my property value is plummeting, and now I'm not going to be able to sell my unit. You know how this spirals out of control. And I'm reaching out to the board and I'm demanding that you get rid of the rabbits, that you replace the flowers, that, you know, whatever it is they want us to do. And the board is sitting there going, well, do we really have to? Well, I don't know that you can get rid of the rabbits. I don't think you should. The other question is, do we then replace these plants? Again, if you are talking to an arborist, for example, and you say, what do we do with this? And they say, hey, our recommendation is you replace them and then you put like a little barrier around them to prevent rabbits from getting there. Maybe that's something we can do, assuming that's affordable for the association. If they say, look, it's not going to matter if you replace it or not. The rabbits will be back. This is just that kind of an area. They're going to come. They're going to chew it. Maybe next season plant something different. Okay, then that's what we're going to do. So you can see how, depending on the type of community, depending on the location of the community, depending on what's in the garden, how all of this is going to evolve and change. But these are the types of questions to ask. So what about woodpeckers? They're making too much noise. Well, again, I want to know, are these woodpeckers, are they natural to the area? Well, I think they are. It's not like the association brought baby woodpeckers, you know, and bred them to be in this association. They are most likely natural inhabitants of this particular area, geographical area. So given that information, and again, assuming that it is reasonable for the association to say, no, we're not going to get rid of woodpeckers because this is where they live, then is remediation even required at that point? If they're just pecking on the trees, should the association be doing anything about it? I mean, the homeowners are going to say, hey, it's a nuisance. Oh, okay, do you want us to send a violation letter to the woodpecker? I mean, what are we going to do with that? We're not going to cut down all the trees. Is there something, again, we can consult with an arborist and say, hey, is there something we can put on the trees to help hopefully deter woodpeckers from coming into our community and making all this noise? I mean, you can always ask. That doesn't hurt. But ultimately, if somebody, if your arborist are saying it's really not a whole lot you're going to be able to do, then I'm sorry that it bothers you, homeowner. You know, put in earplugs, do some background noise so you don't hear them. But this is a natural occurrence. It is not something that the association has control over. So in most cases, we're going to have to tell the homeowner, no, you know, there's nothing you can do. But let's change the facts a little on the woodpeckers. What if it's not the trees that they're making noise on? What if they're actually pecking on the siding? And not only are they making noise, but they are now making holes in the siding, and the association is then responsible for fixing that. Does that change the analysis? Well, I think it changes it in the sense of we might have a duty to repair, and we might definitely want to consult with someone to figure out what we can do to keep woodpeckers from getting on the siding and pecking holes in them. So that might be a separate issue, because now it's become a repair issue of a component that the association is responsible for. So remember, change the facts, change the outcome. But again, no right or wrong answer here. All right, cameras. Okay, so there's a neighbor, they have a camera pointed at my window or at my door. So the first question you always want to ask when you get a complaint from someone about especially something that they are alleging someone else is doing to them, okay? The first thing you do is you make an assumption that that complaint is factually accurate. And then you say, if this is true, in other words, if the neighbor does have the camera pointed directly at someone's door or directly at someone's window, is that a violation of something? Do we have anything in our declaration that prohibits this? Do we have a camera policy that says you have to point cameras only like directly in front of your home? Does it violate anything? And I'm not talking about like a general provision like nuisance, because that's going to be a really hard one to prove, to say that is a nuisance. So does it violate anything more specific than that? And if the answer is no, there may not be anything the association can do. Even though we may not like the situation, and even though we think we should be able to do something, we will not be able to do anything right at that point, because all the association has a legal right to do is enforce its covenants and its rules and its policies. So maybe you say, we should adopt a camera policy at this point for when homeowners install cameras. This is how we expect them to, you know, aim the cameras and what we expect them to do with the cameras. Sure, maybe we do that. And then if it's a violation, we can address it at that point. But even if it is a violation, so let's say we do have a policy and it says you cannot aim your personal cameras at other units. So, and we got this complaint. You don't want to just automatically send a letter. We want to see this camera. We need to do our due diligence before sending our little courtesy notice. And so whether that means, hey, homeowner, send me a photo of this camera, or when you're on property next, you actually find the two homes and you look. And you're not going to believe this, but sometimes we have very sensitive homeowners. No, right? Sometimes the camera's not really pointing at their home. It's pointing past their garage into the street where the homeowner may park his motorcycle, or somewhere, not directly in your window, but past into like the park to make sure there's like no wild animals in there. Who knows what it is? But you have to make sure that whoever is giving you this complaint, once you determine that this could be a violation, you really want to make sure that you can somehow at least verify it. And if you go out there and you see this camera and it's just aimed directly at the next door neighbor's window, okay, let's take a picture of that so we have, visual proof of that. And now we can move forward with some sort of an enforcement process. But a lot of homeowners think that there is some sort of expectation of privacy outside their home. And there really isn't. You have expectation of privacy inside your home. So if a homeowner, if your neighbor like sneaks up into your yard and they put a little camera on your window peering inside right there, yes, that would be a violation of privacy. But if it's on their property and it's just aimed that way, the presumption is, hey, you can close your shutters and they won't be able to see inside there. Now, I know we don't want to have to live with closed shutters our whole life because of the camera, and so it's still a nuisance in that sense. But a lot of people go to this, it's a privacy violation. It usually isn't, though. It usually isn't. And so the key here is what it really needs to violate is some sort of an association policy or rule or covenant. Okay, so when you get those types of complaints, that's really where we want to go with it. The first step is just assuming it's an accurate statement and figuring out whether it's a violation. So next one is neighbors are always fighting and calling the police. Now, I brought this one up because sometimes what we think is common sense is not always common sense and is not actually the correct answer. So yes, is it annoying if you have the police sirens and police lights outside your home on a daily, weekly, whatever basis because your neighbors keep calling them? Yes, it's annoying. Do you, as the association or as the board, have a right to tell people you can no longer call the police because it's a nuisance? No. Think about the liability. Think about now we always say safety is always going to come before any covenants or rules. Safety is always first, it's always primary. And I, as an owner or resident in my home, have a right to feel safe and to take actions that I believe will keep me safe. Now, if I think I'm in danger and I'm calling the police, I have every right in the world to do that. And it doesn't matter if the association likes it or doesn't like it. I have a right to do that. And if we tell the homeowner, don't do it, you can't do it, and then something bad happens to them because they don't, there is a huge, huge liability there. All right. Now, if the residents or owners or whatever are fighting and there's a lot of noise coming from that, and that bothers me as a neighbor, I can't sleep at night, it's noise all the time, yelling, screaming, I have a little kid, they're swearing up and down, I mean, whatever it is, that might rise to the level of a nuisance, and that might be something we can send a courtesy letter for. But remember, ever since HB 1137, these types of violations are virtually impossible for associations to enforce, because the second it stops, that violation is deemed cured. And when it starts again, it's a new violation. It's the same type of violation. It's the same thing that they're doing wrong, but it's a new violation. And under the process for enforcement that HB 1137 created for us, we have to start all over again with the enforcement process, which means sending another courtesy letter. And ultimately, we don't get to the point where we can even impose fines or turn them over to legal for enforcement. So these types of violations are very difficult to deal with, especially for associations and homeowners who don't understand how our hands are tied in these types of situations. And they, of course, are then accusing the board of not enforcing their covenants and every other thing in the book. And Sometimes they do initiate legal action, and honestly, there's no way to get away from that. All we can do is try and keep our homeowners informed. But when you get these types of complaints, I think it's absolutely okay to send a letter about the noise, but not about the police, because that is their right to stay safe and to keep themselves safe. All right. So in general, we've talked about this stuff. I mean, there's a million other examples. I'm sure you guys are all right now thinking about what you've been through with your communities. And I bet you have some really good stories, really good stories. You could write books about it, make TV shows about it. And so by no means is this an all-encompassing informational webinar, but it's just meant to address some things that are strange and not entirely clear to help you at least get an idea of how to think through them. But in general, sometimes there is no right or wrong answer. Sometimes you just got to use your best judgment and do what you think is the right thing to do. Sometimes that's all we can do. But always use your experts, always. Who are the experts? Well, it's anyone who has superior knowledge, that sounds wrong, but who has superior knowledge in whatever the issue happens to be. So it could be an engineer if you're having structural issues. It could be an attorney with legal issues. It could be a CPA with financial issues. It could be a landscape contractor, with those types of issues. So, I mean, and you guys deal with a lot of contractors as it is, and vendors. And so, there's experts out there in almost everything. Use them. I know there are boards that say we don't want to spend the money, but let me tell you why I consistently recommend this. The Nonprofit Act, it has a wonderful, wonderful provision in it. And a lot of you, I bet already know what I'm going to tell you. This provision says, board, if you rely on an expert's opinion in the particular field, you are going to be absolved from liability for your decision. Guess what? It doesn't have to be the right decision. Even if it's a completely wrong decision and you get sued afterwards, you can still get sued. Anyone can get sued. But what happens is then you bring evidence that we have this opinion. We got this report from the engineer and this was the recommendation and we followed it. The judge is going to say, well, you did your due diligence. Statute protects you, board. You are not going to be liable for anything. And they're going to rule in favor of the association. And so, believe me, your boards may not want to spend a lot of money on experts, but they're going to be spending a heck of a lot more money if they don't use an expert and then something happens and then they get sued. You are going to be spending a lot more money. So this is the better option, and you're using the protections the law has given you, and there aren't that many, so use this one. All right. And when all is said and done, I recommend being conservative, because you're better safe than sorry. And like I said, in this day and age, our judges are looking for any little minor technicality they can to rule against associations. So close enough is not close enough anymore. Substantial compliance is not compliance. Okay? Be conservative. All right. Those are my final words now. I guess a little comedic relief, and then we'll get to the questions. I dream of a day when an alpaca will stick its snoot out the window when I'm driving and I can look at it, but that doesn't happen. All right. Let me scroll down. We have quite a few questions, so I'm going to try and get through as many of them as I can. Otherwise, here's my email address. Feel free to email me. I may not be able to respond today, but I will try to get to you as soon as I can, so feel free. Is it common for associations to have to pay property taxes on their common elements? Does the developer need to annex the common elements? If you are getting statements for taxes, you should never be getting property taxes on common elements. Kiowa specifically says that they are exempt from taxes. So that means either there's something going on with the tax assessor's records and they're wrong, or it could mean the developer never actually legally transferred the property. I would get in touch with your attorney if you're getting any kinds of tax requests. All right, next one, raccoons living in wastewater outlets. Oh, we are responsible for maintaining many of the outlets. City doesn't address raccoons in there, so we haven't either, but we get complaints. Should we get a professional opinion about whether we should do something, just out of precaution? Well, I will tell you, if you're going to be conservative, you absolutely should get an opinion and follow that. Question is, who do you get an opinion from? Is this something where the Division of Wildlife needs to come in and tell you? Maybe. I don't know that it's so much a legal opinion. I think it's more of like a wildlife type opinion. But yeah, I would say better safe than sorry. Be conservative. Get the opinion. Next. I had a realtor send over an inspection report for a sewer line needing to be cleaned and noted a bulge in the pipe. But they have a measurement out from the unit to the city main. Insurance and maintenance chart shows this is a homeowner responsibility, but the HOA pays for water sewer. How do we determine if the HOA is responsible for the sewer line, or if there is a point in the line where the HOA would be responsible? So it depends. I mean, in your message, you're saying that there's a measurement and you know that where the bulge is in that portion is where the homeowner has to maintain it. So to me, fixing a bulge is very different than being responsible for the water and sewer or paid for that. I would say if the bulge is in the portion of the pipe that the homeowner is responsible for, then it's that homeowner's obligation to fix that bulge. But again, change the facts, change the outcome. I don't know that that there's enough information for me to say anything other than that. All right. Does damage caused by rodents and getting rid of the rodents fall under the same umbrella? Or if you find that the rodents go in through a siding, you have to fix the siding and get rid of the rodents. In most cases, if the association is only responsible for the exterior, we would fix the siding, and then the interior portion, if that's the homeowner's responsibility, then they would be taking care of the interior portion and getting rid of the rodents in that case. It's going to be specific, obviously, to the documents. It's also, you're going to look to see did the association screw anything up? Did we fail to properly maintain that siding? And that's why the rodents got in. If so, we may have some sort of an obligation to pay for some of the, some of the processes that are going to go inside the unit to get rid of them. But it depends. But like I said, if there wasn't any negligence, then ultimately we would not have a responsibility for the interior unit if that's a homeowner's obligation. How would you prove that there are hoarders? Well, that's a great question. I mean, a lot of times you can't prove it. And I know we use that as an example, like if someone's a hoarder and they cause the roach infestation or whatever infestation, you may not be able to prove it. But if you do, if you have someone actually inspect the exterior of the building, if that's the association's responsibility, and they say there's nothing wrong with it, there's nothing going on here that can cause an infestation of rodents, I think at that point, then the association can say, sorry, there's nothing that we need to be doing here. It's all coming from the inside. So whatever it is that's going on inside your unit, you're going to be responsible for it. If the HOA has previously done work in a condo attic, is that good enough to say the HOA is responsible if additional repairs have to be made in the attic? Not necessarily, and it really depends on, I think, what kind of work has been done in the attic, why it was done, what were the circumstances, are we doing work in all the attics? So I think that is something that you would probably want, the association to have an opinion on, because I think it's really going to depend on what the circumstances are in that particular case. Would quail be domesticated, or are they fowl and not allowed in the HOA if HOA does not allow fowl. Part 2 of the question, what about pot-bellied pigs? So this is going to be a little bit outside the scope of what we talked about today in the webinar. So shoot me that email to me personally, and I can talk to you about that off the record. Okay, last question because it's 1 o'clock. Regarding wildlife poop, including deer and elk, on city sidewalk in an HOA, is the HOA responsible to have the ground company to remove deer and elk poop? The answer is it's going to depend on whether the association maintains those sidewalks. Just because they're owned by the city, that doesn't mean that we don't have to maintain them. A lot of times there's ordinances that say we maintain them. A lot of times there's agreements the developer made with the city saying we have to maintain it. So that being said, thank you all so much. Please, if you have time, do the survey, and I really appreciate you joining us. See you next time.